I'm attorney William Moore, and I'm going to break down all of the key components of the Florida jury trial. This is the best way for criminal defense attorneys to get an idea as to how they're going to spend their time honing their skills as they research and study and fine-tune the art of criminal defense, especially when it comes to trials. The first component is, of course, jury selection. This is a absolutely huge part of the trial from a defense standpoint. I can't emphasize that enough. This is known as voir dire, and we're all familiar with it. Peremptory challenges, challenges for cause, convoluted methods of picking jurors, and ending up with 6 to sit. Next is the opening statement on the prosecutor's side. This is where the prosecutor gets up and states all of the evidence that he or she believes is going to come in that tends to establish the guilt of your client sitting there next to you. Following the state's giving an opening statement, everyone in the courtroom will expect you to get up and give an opening statement. But let's say this was a misdemeanor offense, like a DUI. I would reserve, you should reserve. That's a powerful thing to do. Most lawyers aren't really keen to this. I guess what it means, most prosecutors aren't, and kind of catches them off guard a little bit, confuses them a bit, which isn't the point, but it's just one of those things that surprises us from time to time. This is a tool that isn't used. Anyway, next we've got the case in chief, the direct examination and cross-examination by the defense of state witnesses. Once the state rests their case, the defense is going to make their motion for judgment of acquittal. It's always required. I don't care if the state just put on the best case on earth and they've gotten each element and they've compounded the prima facie case by tenfold. You still make your motion for a judgment of acquittal. Defense has to. It's malpractice if you don't. Now, if you reserved, if it's a lower level case or depending on the facts and circumstances of the case, you should be giving an opening statement at this time. Following the defense's motion for a judgment of acquittal, if the defense's reserved opening statement, this is when you're going to get up and you're going to tell the jury everything that your client and your witnesses are about to say. This has an astronomical benefit when done correctly. And we're going to get more into that in later lectures. But it's good stuff. After the opening statement, if you've reserved, if you haven't, you're going to put on your case in chief, the defense's side of things. And when you rest, jury will be excused. There'll be what I guess the best way to refer to it as the proposed jury instruction hearing. I always have to argue about these things. Sometimes the litigants stipulate to them. But jury instructions also can really play a key part just for subtle hints to the jury that can sway things in your direction. And these things can be done without the state attorney or even the judge really knowing what you're trying to do. Anyway, following the jury instructions being agreed upon or a decision being reached as to what's going to be read, the jury's instructed by the court. And you sit there and listen to the instructions that you've heard hundreds of times throughout the last 20 years. Now we're up to closing statements. Used to be that depending on whether or not the defense put on evidence, that would dictate who started, who closed first, and who got stuck in the middle and only got to talk once. But now the Florida legislature has said no. the prosecutor always goes first, gets up, does closing. Then following the first part of the prosecutor's closing, the defense gets to get up there and give their entire closing. Once the defense finishes their closing argument, there's the second part of the prosecutor's closing. Call it the rebuttal closing. Once all this is concluded, the jury is going to be escorted by the bailiff back into the jury room, and they're going to begin deliberations. And you're going to wait until there's a question. I always get questions in my trials. I think everybody gets at least one in their jury trials. So that, of course, leads to hearings on the most appropriate and proposed answers to jury questions. Most of the time, you're going to get a judge, the court is going to tell the jury that they can't really give them any information at this point. But the way it's worded is important. After all this is concluded, guess what? That buzzer goes off twice and you get a verdict. Or, as in the case of 4 of my trials this year, hung juries. That's also going to be a great section coming up. If you get the occasional hung jury, what to do in the ensuing trial. But most of the time, at this phase of the Florida criminal jury trial, you get a verdict. And remember, defense attorneys, try not to brag when you win. I'm William Moore.